Hey, this is Angela, and you're listening to the Study for the Bar in Your Car podcast. The podcast where you can study for the bar in your car just by listening to these lessons here. So my name's Angela. I'm your hostess, and today I'm here with my friend, my very good friend, my dear friend, Talib. Hi, Talib.
Oh, hi.
And
I
Talib,
wasn't expecting such a embellished introduction.
yes, well, Talib is a dear friend of mine. We go way back. He's not into law. He's not a lawyer at all. He does do some stuff, some work with estate planning. But one reason why I brought him on here is because he has been a fantastic supporter of mine, at least morally, um, and just he's really been a champion of me through this whole law school journey. Now, the one thing that is a little bit difficult is that Talib, his birthday, um, always happens around the same time as the bar exam. So I've been trying to pass this bar exam for a while now. So I've been missing his birthday in the summer. And I feel very bad about that because I want to be able to celebrate him and celebrate his birthday. And I also don't want him to feel like a friend that's been abandoned. So,
Well, you
Talib,
can always make it up with better presents
yes.
and lobster dinners. So
Okay.
um, I am waiting. I do have a credit.
Right, right. So, okay, Talib, how do you feel that your birthday falls along the timeline of the summer bar exams?
Um, it doesn't bother me, but I do take great offense that it has been a constant excuse for a number of years. And but I do my best to deal with it, and I just keep adding on the lobster dinners to compensate. Um,
Right.
so once you pass and you get that job, the bill is always yours.
Okay. Okay, okay. Well, wait. Lobster dinners. I think the last time we visited this topic, it was actually shrimp dinners. Have you upgraded to lobster dinners now?
Well, previously in your past life, um, a lobster, a shrimp was fine. But as you're older, as you're excelling in your career, as you're helping to change the world and make the world a better place through the law, I would expect a little upgrade. So,
Okay. So, all right, maybe I'll think about it. Right.
oh,
So, the next topic we're going to get into is with jury trials and the right to a jury trial.
I
And
actually am excited about this.
have you ever have you ever been on a jury?
I have never been picked
Okay.
for a jury, but you know, every time some case comes up on the news, and there's a very prominent case going on right now. I live for it. I live for the objections, the sustaining, the jury, picking the jury. I live for it all. That is my I hate to say it, it becomes my form of entertainment. It's not my life, but it's it's fascinating to just kind of watch the proceedings on television, or or reading every day through the news.
So, just for those who may be tuning in at some later point, the big trial that's on now is the one with P. Diddy.
And Sean Combs.
Sean Combs, yes. And my one connection to this trial, not really trial, but to Sean Combs is that I was at a party at him, not one of his freak off parties. It was like very above the board.
Allegedly.
It was it was for the Independent Black Film Festival. And anyhow, I literally got elbowed, like he physically elbowed me like out of his way. Um, so all I can say now is, hey, karma, right?
I
Um,
would say this. There's more to this story. So when the Patreon series comes out, I would suggest everybody paying the Patreon to hear the full story.
okay. So, um, the way that this works is that I'm just a law student. Like, I'm not this huge expert. I probably should be an expert with all the bar study that I have, but I haven't passed a state bar yet. And what I've done is I've taken all my bar notes, and I've got lots of notes, like thousands of pages of notes that I have on, like, ranging across all these topics for the bar exam. I've put my civil procedure notes into AI, and I had it generate a podcast. And um, so what you're going to listen to are these two bots. I call them Maud and Claude, and they just go through all the notes that I have. So, a few things that you need to keep in mind, right? As I mentioned, I'm a student just like you. I am not an expert. I haven't passed a state bar. I'm not a lawyer, and I'm not giving legal advice. I've literally just put my own comprehensive notes into AI, and the podcast that you're about to hear is the resulting podcast. AI isn't always correct, so don't come for me if there's an error. If I do find a mistake, I will do my best to correct it. I listen to the podcast after they're done, and if there's anything that's not correct, I either redo it or take it out. But I can only do that to the capacity of my own knowledge. So if there's something that's wrong and I don't know that's wrong, I'm so sorry. But I try to keep things correct because I've got a lot of notes. And just so you know, I've been through law school. I want to say twice, but actually three times, because I'm a dual American British citizen. So I went to law school in the UK, I went to law school in the US, and then I got a advanced degree in law in over here in the US. And lastly, if you're driving, the most important thing is for you to be safe on the road. So if civil procedure really gets your blood boiling, and you need to stop or pull over, please do so or put it on pause. But hopefully, none of this stuff is too contentious and you can study and have fun with it. Anyhow, if you need to reach me, my email address is podcast@studyforthebarinyourcar.com. And if you need me to do any legal work, so I don't ask you for donations, but what I do ask is that if you are an attorney or you know an attorney who needs help with some legal work, so maybe they've got too much work on their hands and they need a law clerk to help them get through some stuff, call on me. I can do the work. You can email me at hello@legalwriterandlawclerk.com. Now, I know those email addresses are totally long, but you should get the idea. hello@legalwriterandlawclerk.com. Again, my name's Angela. I'm so glad that you're here. I'm glad that Talib is here. And
I am here.
yes. So any parting words until we listen to this podcast with Maud and Claude?
No, I'm so looking forward to this. This again, it just feeds into all the stuff that's going on in the news right now, and I just sitting back with my notebook, taking notes myself.
Okay, that's great. And I think one advantage in New York, and this is actually on an episode of Sex and the City, is like when I'd have to go down for jury duty, it was right near the Century 21. And I'm dating myself because I don't even know if the Century 21 is still there. Um,
It is just reopened.
oh, awesome. So it's like you could go down for jury duty and then go shopping at Century 21 afterwards. Um, anyhow, that's by the by. All right, here are our hosts, Maud and Claude. Take it away, guys.
Welcome to the deep dive. Today, we're diving into jury trials. Such a fundamental part of the legal system, right? But, really understanding how it all works can feel, well, a bit opaque sometimes.
It really can. And for this deep dive, we're actually using Angela's notes on jury trials, which are fantastic.
Oh, right. Angela's perspective is so valuable, especially, from her time as a judicial law clerk.
Yeah.
Didn't she observe a lot of the jury selection process?
Yeah, exactly. She often observed voir dire, which is, the formal name for jury selection. So her notes have this great practical layer to them.
Okay, perfect. So let's get into Angela's outline then. It looks like she breaks it down into, what, 3 main areas?
That's right. First, the basic right to even have a jury trial. Then, how juries are actually picked and sort of put together.
Selection and composition, okay.
And finally, jury instructions, which are super important, and the rules around those.
Got it. So our goal here is really to give you a clear, kind of engaging overview, focusing on the key rules from Angela's notes and what they actually mean in practice. Sound good?
Sounds great. Where should we start? Angela kicks things off with the cornerstone.
The right itself.
Exactly. The right to a jury trial.
Yeah.
In federal court, this comes from the 7th Amendment, specifically for suits at law.
Suits at law. Okay, that definitely sounds a bit old-fashioned. How do we translate that for today? What does Angela's outline say?
Well, Angela's notes clarify that figuring out if something is a suit at law versus a suit in equity, it really boils down to the remedy. What is the person asking the court for?
Okay.
Generally, if you're asking for money, monetary damages, that's typically seen as an action at law. And that triggers the right to a jury trial.
Okay, so money damages do a jury trial, usually. What about the other kind? Equity.
Equity is more about non-monetary relief. Think injunctions, court orders telling someone to do something, or more often stop doing something. Those are typically decided by a judge alone.
Right, so like if someone gets hurt in a car accident and sues for their medical bills and pain and suffering, that's money, so it's at law, and they get a jury.
Exactly. Angela uses that as a classic example in her notes. Perfect illustration.
Okay. But what if a lawsuit mixes things up? Like someone wants money and an injunction.
Yeah, that happens all the time. Angela's notes are clear on this. Even if you're asking for equitable relief, like that injunction,
Right.
if you're also asking for money damages, you don't lose your right to a jury trial on the money part.
Interesting. So the legal claim, the money part, still gets a jury.
Precisely. Angela emphasizes that every legal issue within a case keeps its right to a jury trial, even if it seems kind of secondary to an equitable claim.
Okay, that's a really important point.
And there's another layer. If you have both legal and equitable claims in the same case, and they share common questions of fact.
Like the facts needed to decide the money claim are the same facts needed for the injunction.
Exactly. Angela points out there's a specific order things have to happen in. The jury has to decide the legal claim, the money part first.
All right. Why first?
To respect the jury's role. Their findings on those shared facts are then binding when the judge later decides the equitable claim. The judge can't contradict the jury on those same facts.
I see. That makes sense. Prevents conflicting decisions on the same evidence. So, for you listening, you might encounter this right to a jury trial in, well, personal injury cases like we mentioned, or maybe breach of contract cases, seeking damages, things like that.
Right. Business disputes over lost profits often involve it too.
Okay, so that covers the fundamental right based on Angela's notes. What does she dive into next? The actual jury.
Yep. Next up in Angela's outline is the selection and composition of juries. And this is really where her direct experience observing voir dire comes into play.
Voir dire. That's the questioning part, right? Trying to find impartial jurors. Angela must have seen some interesting exchanges there.
Oh, I'm sure. Angela's notes explain that voir dire is how the lawyers and the judge try to figure out if the potential jurors in the pool can be fair and unbiased.
So after they figure out who could be on the jury, what are the rules about the actual size and how they decide?
According to Angela's notes on federal civil cases, the jury has to have at least 6 members.
Minimum 6.
And no more than 12.
6 to 12. Got it. And the verdict, do they all have to agree?
Generally, yes. The standard rule Angela flags is unanimity, unless the parties agree differently beforehand.
They can agree to not require unanimity.
They can, yes. But the default rule is a unanimous verdict, and it has to be returned by a jury of at least 6 members.
Okay. Unanimous seems tough sometimes.
Yeah.
Now, during that voir dire process, lawyers can get rid of potential jurors, right? How does that work?
Right. Angela discusses the 2 main ways: challenges for cause and peremptory challenges.
For cause seems straightforward.
Yeah.
If a juror clearly says they're biased or, they know the defendant personally or something.
Exactly. If there's a demonstrated reason why they can't be impartial, they can be challenged for cause, and the judge decides.
But what about peremptory challenges? Those are the ones where lawyers don't have to give a reason, right? They just strike someone.
That's the traditional idea, but it's not quite that simple anymore. Angela's notes really emphasize the limits here, specifically highlighting Batson challenges.
Batson, okay. Sounds important. What does Batson do?
Batson v. Kentucky is a Supreme Court case, and its legacy, as Angela explains, is that you cannot use peremptory challenges to exclude potential jurors simply because of their race or gender.
A protection against discrimination in jury selection. How does that actually play out? Like, how do you prove someone was struck for that reason?
Angela outlines a 3-step process. First, the party objecting, let's say they think a juror was struck because of race, has to make what's called a prima facie case. They need to show circumstances that raise an inference of discrimination.
Okay, step one, raise the suspicion. Then what?
Then the burden shifts. The lawyer who made the strike has to come forward with a neutral explanation, a reason for the strike that isn't based on race or gender.
Like they didn't like the jurors' answers about something specific to the case.
Could be. It just has to be neutral on its face. But that's not the end. Step 3, as Angela describes it, is the judge deciding. The judge looks at the reason given, considers all the circumstances, and decides if the objecting party has actually proven purposeful discrimination. Was the neutral reason just a pretext?
So the judge makes the final call on whether the explanation is believable or just a cover. That's a crucial check.
Definitely. It's aimed at ensuring the jury pool isn't unfairly shaped. Angela also mentions polling the jury. What's that about?
Polling, like asking each one individually.
Exactly. After the verdict is announced, but before the jury is let go, Angela notes that a party can request, or the court can decide on its own, to poll the jurors individually. They basically ask each juror, is this your verdict?
Why do that? To double-check the unanimity.
Precisely. If the polling shows that the verdict actually wasn't unanimous, or didn't meet the minimum number if they agreed to less than unanimous, then there's a problem. Angela's notes say the court could then either tell the jury to go back and deliberate more.
Try again?
Right. Or the court could declare a mistrial and order a whole new trial.
Wow. So thinking about news reports on big trials, sometimes controversies about jury selection or questions about the verdict might involve these Batson rules or maybe even jury polling happening behind the scenes.
Absolutely. These procedural rules are working in the background.
Okay, so we've covered the right to a jury and how that jury gets selected and composed. What's the final piece in Angela's outline?
The last critical area Angela covers is jury instructions and the rules around requesting them and, crucially, objecting to them.
The instructions. This is where the judge tells the jury the law they need to apply, right?
Exactly. They are absolutely vital. They guide the jury's whole deliberation process. The judge explains the relevant legal standards and how the jury should use those standards when looking at the facts they heard.
Kind of like the rule book for their decision-making.
A perfect way to put it. And because they're so important, Angela's notes stress the specific procedures lawyers have to follow. First, if a lawyer wants a particular instruction given, they request it. But maybe more importantly, if they think an instruction the judge plans to give or has given is wrong,
they have to object.
Yes, and Angela emphasizes how critical this is. To preserve the issue for a potential appeal later, the lawyer must object on the record.
On the record, meaning saying it out loud in court so the court reporter writes it down.
Correct. And it can't just be a general complaint. Angela notes they have to clearly state what they're objecting to in the instruction and the specific legal grounds why they think it's wrong.
And timing matters too, right? You can't wait until after the trial is over.
Definitely not. The objection has to be timely. Angela explains this usually means making the objection promptly after learning that the instruction will be given, or maybe that a requested instruction has been refused before the jury starts deliberating, essentially.
So if a lawyer messes this up, they don't object, or don't do it properly, what happens if they later realize the instruction was bad? Are they just out of luck on appeal?
Pretty much, usually. According to Angela, failing to make a timely and specific objection generally means you've waived the right to challenge that instruction on appeal.
Waived it. Gone.
In most cases, yes. The only way an appellate court would likely review an unobjected to instruction is under a very tough standard called plain error.
Plain error. Okay, that sounds significant. What does that actually entail based on Angela's notes?
Angela explains it's a high bar. To show plain error, the lawyer appealing has to demonstrate, first, that there was an error, second, that the error was plain, meaning clear or obvious, not subtle, and third, that the error affected the party's substantial rights.
Substantial rights? Does that mean it likely changed the outcome?
That's usually what it boils down to, yes. The error has to be so significant that it probably prejudiced the party and affected the trial's outcome, leading to a manifest injustice. Think. An obviously incorrect statement of law that likely caused the jury to reach the wrong verdict.
Wow. So the message is clear. Lawyers better pay very close attention to those instructions during the trial and speak up immediately if something's wrong. Otherwise, fixing it later is incredibly difficult.
That's the key takeaway. However, Angela does add a small caveat. even without a proper objection. If an error in the instructions was truly obvious and substantially damaging, an appellate court might still intervene under plain error, but you absolutely cannot count on it.
Can you give us an example? What might qualify as plain error in an instruction?
Sure. Angela gives a good hypothetical. Imagine a case involves an affirmative defense, say, statute of limitations. But imagine that specific defense was recently abolished by the legislature, effective before the trial started.
Okay, so the law changed.
Right. But if the judge, maybe by mistake, still instructs the jury based on that old, abolished defense, and the jury clearly relies on it to reach their verdict.
That seems pretty obviously wrong.
Exactly. That could very well be plain error, even if the lawyer didn't catch it and object at the time. It's a clear misstatement of current law that directly affects the outcome and substantial rights.
That really drives home the importance of getting those instructions right. Okay, so we've journeyed through the right to a jury, how they're selected, and these crucial instruction rules, all guided by Angela's notes and her experience. Let's try to sum up the main points.
Absolutely. I think the key takeaways from Angela's outline are, first, the Seventh Amendment gives you that right to a jury in federal civil court, mainly when you're seeking money damages, suits at law.
Right. Money damages, you choose right.
Second, jury selection, or voir dire, is a careful process involving challenges, with important limits like the Batson rule against using race or gender to strike jurors. And juries are typically 6 to 12 people, usually needing a unanimous verdict.
Okay. Selection is structured and aims for fairness.
And third, jury instructions are the legal roadmap for the jury. Lawyers must object specifically and timely to any perceived errors in those instructions to preserve the issue for appeal. Otherwise, they face the very high hurdle of the plain error standard.
Object or likely waive it. Got it. And weaving through all of this is Angela's practical experience, especially watching voir dire, which really adds color to these rules.
It really does. It grounds the rules in courtroom reality.
You know, when you think about all these detailed rules, the specific requirements for objections, the steps in a Batson challenge, the precise numbers for jury size, it really highlights how much effort goes into trying to make the process fair.
It does. It underscores the importance we place on the jury system, but also maybe the need for an informed public who understands, at least generally, how it's supposed to work.
That's a great point. And it leaves a final thought for you listening. Considering these complexities we've discussed from Angela's notes, what does this intricate system of rules tell us about our pursuit of justice? How well do these procedures actually work to ensure a fair outcome in the real world?
That's something worth pondering. And maybe it sparks your interest in another aspect of civil procedure or trial practice that we didn't fully explore today. There's always more to learn.
Absolutely. Well, thanks for taking this deep dive with us into the world of jury trials.
Okay, I'm back. It's Angela and Talib.
Hello, hello, hello.
And yeah, we're your real live people as opposed to Maud and Claude, who you heard go through my notes about jury trials and the right to jury trials and so on. So yeah, Talib, I think you had a jury story you wanted to tell.
Well, I'm assuming it's been so long that I hopefully I won't be in trouble for this. But I've only been called 3 times for jury duty in my life. And the first time didn't even get into I didn't really even get into the mix. But the last time I went downtown and I did the selection room, and I'm looking around and people are getting picked.
Right.
And it gets down to the number, like there are like 4 slots left.
Right.
From people that have been excluded.
Right.
And this woman is making a real big deal that she didn't want to get picked. And I remembered the Larry David conversation around when he was doing his jury selection.
Mm-hmm.
And as they were talking, so this woman gets off. So then there's like 3 spots left. And, the other woman looked a little off. The other guy looked a little off. And there are only 5 of us.
Right.
So I go, and so when it's my turn to be asked a question, actually, even before I was asked the question, I heard something that they said something about how this how the plaintiff was injured. And I just blurted out, how fat was this kid?
Oh my God.
And and they stopped me, they did a little huddle, and then they said, you're free to go.
Oh, that's excellent.
And that was the last time I've ever had jury duty. But actually now I would like to do it.
I did it and it was really excruciating. And this is way before I was into any law stuff. And it was a jury, like, and one thing that sort of sucks about, like, if you're on a jury, well, it can suck if you're on a jury, is that, and if you're on a jury and you're like the only type of person there. So like if you're the only woman there, if you're only the only man there, but I was the only Black person there in New York City, like in the jury. So it was like New York City, which is a pretty diverse city. And for whatever reason, I was like the only Black person on this jury, which is a little bit frustrating. And the defendant was Black. And so I didn't think he was guilty, not because he was Black, but just because the facts to me didn't add up. But to all the other people, like, they're like, he's guilty, he's guilty, he's guilty. And then, so it came down to me and they were like, you don't think he's guilty because he's Black. And I'm just like, I don't think he's guilty because I don't, like, it's not adding up to me. But they put the pressure on me, not because I don't think they were trying to like bully me racially or anything, but some of the people there were like they worked for themselves and they were like independent contractors, and it wasn't like I was missing work and I was fine with that, even though they were paying me like $5 a day or whatever. But they were like missing like, people who were making hundreds, and they just wanted it to be over. Like they wanted me to like just agree with them so it could be over. And I wasn't going to do that. I was holding fast to my beliefs. And so it like, I think when I left there, I was in tears. I was crying, not because of, of the defendant, but I was just like, I just felt so like put through the coals emotionally from that. And I was just like, I will never serve on jury duty again. Now I would now, but now they probably won't have me because I'm into law stuff. But anyhow, that's another story for another day. So T, thank you for joining me for this.
I loved it. I can't wait for more.
Okay. All right, listeners. As I mentioned, one, I'm not a lawyer yet. I'm not giving legal advice. AI isn't always correct. And, the way that Maud and Claude said voir dire was really weird. It was like lawyer, dar. So you can see that AI isn't always correct. But I do my best to correct it. It's sort of hard to correct their pronunciation when it's wrong. But anyhow, if you're driving, stay safe, and we'll see you on the next podcast. Take care.
Bye.
Bye.